Hello, we're looking at criminal law. We're currently in week 2, and we're looking at criminal responsibility. So, to start off with, we've got the standard of proof, and there's 2. In criminal law, we've got beyond reasonable doubt. In civil law, we've got on the balance of probabilities. So, if you don't know the difference, criminal law is where the state sues someone for committing a crime. Civil law is where one person sues another for defamation or whatever. Now, in criminal law, the standard is beyond reasonable doubt. This is seen in Wilmington versus the Director of Public Prosecutions. In law, we like to define terms, but this term here, beyond reasonable doubt, is intentionally left vague and ambiguous. The idea is that the jury decides what beyond reasonable doubt means, and then they can measure the criminal against their own standard. So there's that. Civil standard is on the balance of probabilities. This is more of like what is a more likely instance to have occurred. That's a bit more statistic based. So if it seems like someone's committed defamation, then and it seems like there's maybe a 51% chance, then that person would be deemed guilty. So beyond reasonable doubt, the elements of a crime include capacity, conduct, fault, coincidence, and no defense. And each of these must be proven beyond reasonable doubt. If the defense can claim that, let's say, the criminal didn't have the capacity to commit a crime, even if they can create some doubt that the criminal didn't have proper capacity, then in theory beyond reasonable doubt is not met. So the burden of proof, so basically the person who has to prove something is always, or usually, the person who accuses. So, I've got to create a note there. So the Director of Public Prosecutions, that's like when someone commits a crime, the person who takes the criminal to court, criminal defendant until they're proven criminal. And it's on them to prove the case. In civil cases, it's the first accuser. Unless the defense is trying to prove something like criminal insanity. In which case, it's up for the defense to prove that their client was insane at the time. So this is all found in most of this. This part here isn't. I just wrote that in. But everything else is found in the Evidence Act, 1995. So we're looking at 3 elements of crime in this week. We're looking at the actus reus, or the guilty act, mens rea, or the guilty mind, and capacity. So to start off with, we've got actus reus, which can either be prohibited conduct, prohibited circumstance, or prohibited consequence. I've got some examples there. Prohibited conduct can be assault. Prohibited circumstance is something that could be legal in one circumstance but is illegal in another. Or prohibited consequence, death of another. If someone dies nearby me, then I may be guilty of crime. The act can either be a positive act or an act of omission. They have no legal obligation to act. If I'm driving down the road and someone's bleeding out, I don't have to pull over and help them. Probably makes me not a good person if I don't do that, but it's not illegal unless one of these 4 things are met. So first off, if there's a dangerous situation, in R.V. Miller, this was a case where I think a guy was drunk, he was squatting with a couple of other people, he was smoking a cigarette, and then he went to sleep. And then he woke up halfway through the night and realized that his cigarette had started a fire on the mattress. And instead of putting it out or calling for help, he just went to another room, went to sleep. And then the next time he woke up, there was, the fire brigade came, the police came, and all that kind of stuff, and he was guilty of arson. And that's because he created the situation and he didn't do anything to help people, or he didn't do anything to try and fix the situation. So that's a dangerous situation. Relationships, so a parent has a duty to act for their child. If the child's in danger and the parent does nothing, the parent is criminally responsible. In R.V. Russell, I think I forget the exact details, but this guy called Russell, I think his wife threatened to leave him if he didn't act in some sort of way, and so her and the kids walked out into the ocean and he just stood there and let it happen, and he was found guilty. Statute, if a place has Good Samaritan laws, if you've seen the last episode of Seinfeld, they all get booked because of this. Assumption of duty. If I say I'll do a life-saving act, then I don't, that's omission. So if I say, don't worry guys, I'll make sure forgetful grandma takes her dementia pills, and then I don't, then that's omission. I think in a more maybe a more practical aspect. I don't know if this is true, but let's say a paramedic is on scene, or a paramedic is around, and then though they're not called to a first aid thing, someone has an incident just further up the road. If they don't act, then that could be a crime, although I don't know if that's true. Voluntariness is an action, so a crime must be voluntary for it to be a crime. Involuntary acts don't count as crimes, so I remember we did this exercise in my class where if you're whacked here, bang, you kick, and then that triggers off some terrible chain of events, then you're actually not criminally responsible because you didn't volunteer to do it. Voluntariness can be assumed by the prosecution, but if the defence raises doubt, then again the criminal standard applies. So this is more things like if I'm having an epileptic seizure and then during then I accidentally stab someone, that's a bit drastic, but that could be an involuntary action. So that's the actus reus part right there. Mens rea. Elements of a fault are either subjective or objective. So what this means, subjective is in the mind of the criminal. Objective is whether a reasonable person would determine that the person was guilty. So subjective elements include intention. If I get a gun pointed at you and shoot, then that's, and I've intended to do that, then that's intention. Recklessness is where you perceive risks and you do the thing anyway, and then the bad thing happens, right? So if I'm driving, going 100 k's an hour in a speed zone, there might be maybe 60 miles per hour. So 100 k's an hour in a school zone, and I hit someone, then I'm guilty of murder, even if I didn't intend to hit someone, because I recognized the risk and I did it anyway. Objective elements, so elements where a reasonable person would determine whether something is a crime, include negligence and knowledge. So R.V. Lavender is a negligence case where this guy was driving some sort of heavy machinery, like a forklift or a digger or something, and there were a bunch of kids and they were playing near a minefield. This all takes place near a minefield. Mining area, mining bit of land where mines happen. And a guy was driving a piece of heavy machinery trying to tell kids to move out of the way, kids. And then one kid got in front of it and the guy drove over with this heavy machinery, crushed him and died. And the kid died. So that's an example of negligence where, a reasonable person could have looked at that and went, okay, well you can clearly perceive the danger there. A reasonable person could. You didn't, so therefore you're guilty. Knowledge is another objective test. And it only applies for crimes of possession. So if somebody's planted drugs in my backpack, I didn't see it, I didn't know it happened, and then I'm accused of it. Well, I didn't know, so I am innocent. Transferred intent. This is a pretty interesting scenario, where if we've got this person here, right, and then I point a gun here and I shoot this person intending to kill them, they duck and I hit this person, then I always legally intended to hit this person. That's kind of what happened in R.V. Latimer, where a guy went to kill another guy, and then the bullet bounced off the guy's belt or something like that, hit a nearby woman, and then the guy was. It was said that the guy always meant to hit the woman. Temporal coincidence, as in coincidence, two incidents that occurred at the same time, not as in like, oh, what a coincidence. This means that the intent to commit a crime, so the mens rea, and the act of the crime, actus reus, must occur at the same time in order for it to be a crime. So if I stab someone and then immediately regret it, too bad, that's no offence, because I wanted to do it when I committed the crime. If I wanted to commit a crime at 10 o'clock and then decided maybe I shouldn't do that at 11 o'clock, and then 2 o'clock came and then I involuntarily killed someone, there is a defence in that, because the act and the mind didn't occur at the same time. Capacity is the ability to know right and wrong. The most obvious example of this is kids, but things like dementia patients, criminal insanity, that kind of thing, those can determine capacity too. So children, that's the obvious example that we looked at in class. They're considered not capable of committing a crime until they are 10 years old. The reason being because they don't know the difference between right and wrong. They can't understand morality, that sort of thing. There's a case, RP versus the Queen 2016, which is where this sort of information is sourced. There's this rule called Dolly Incapax, which is I forget I think it means incapable of crime. And that applies for kids aged 10 to 14 years old, though it can be rebutted. If you can prove that an 11-year-old does have a good grasp of morality and a good grasp of what's right and wrong, then Dolly and Pax goes out the window. So RP versus the Queen tells us that if a child knows that their act is immoral, or seriously wrong, or gravely wrong, then they can still be deemed guilty. And the big question looked at is, should Australia's child criminality age change? Now this was relative to, I'll pull out my notes, some other places like America doesn't have a legal minimum age, so a 3-year-old can be convicted of a crime assuming that they knew that it was, assuming nothing, that's it, they can be convicted of a crime. In China, age of criminal responsibility doesn't start until you are 14 years old, if it's a serious crime, or 16 years old if it's just a not serious crime. In Pakistan, criminal responsibility starts at 7 years old. So that's sort of a thing. So in America, for example, where there's no legal age, a 7-year-old who's committed a heinous crime will be treated as an adult would. That's pretty much it. Actus reus, mens rea, capacity. These are 3 elements out of 5, which must be proven beyond reasonable doubt. Thank you for listening.